Considered the record, the oral statements made, the victim impact statements, the trial testimony and evidence, the pre-sentence report from several years ago, the updated criminal history, my conference in chambers with counsel and probation, and the statements of the defendant and the defendant's counsel. The court has also considered the overriding purposes of felony sentencing pursuant.
All right, pay close attention here. This might sound like legal boilerplate, but this is actually where judges lay the foundation for a sentence that can survive an appeal. Every factor the judge mentions now, from victim impact to criminal history, becomes part of the official record. And judging by his tone, this isn't sounding like someone who's about to hand out a second chance.
Need for incapacitation, deterrence, rehabilitation, and restitution. I've considered the recommendations of the parties, including the sentencing memoranda. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society and the victims, and to be consistent with sentences imposed for similar crimes committed by similar offenders. In using my discretion to determine the most effective way to comply with the purposes and principles of sentencing, I have considered all relevant factors, including the seriousness and the recidivism factors set forth in divisions B through E of Revised Code 2929.12. In that regard, there are factors making the offenses more serious. The victim suffered serious psychological and economic harm. And I'm talking about Mr. Gonzalez. I believe he needed psychological treatment as a result of this. The economic harm was substantial. The Murillos suffered significant psychological harm for the home invasion that occurred as they arrived at their place of residence. This was committed as part of an organized criminal activity. There were 3 people involved in this. There are no factors making the offenses less serious. In terms of recidivism, the offenses were committed while on post-release control from the previous time that I sent the defendant to prison for a crime of violence. The defendant has an extensive previous criminal history and history of juvenile delinquency. He's been to prison 3 times on 4 cases. He's got 9 prior crimes of violence before this case.
And now we reach one of the biggest moments in any sentencing hearing, recidivism. That's just the legal term for the likelihood that someone will commit crimes again. The judge has already found no meaningful mitigating factors, and now he's about to examine the defendant's past. If that history is as bad as it sounds, every prior conviction becomes another brick in the wall, leading to a much longer prison sentence. Were you expecting this to go any other way?
And yet committed this offense less than 8 months later. There's a pattern of drug or alcohol abuse, and the offender refuses to acknowledge a problem or accept treatment. There's been a rehabilitation failure after previous convictions and delinquency adjudications, and a failure to respond in the past to probation or post-release control. The court determines that the offenses were committed under circumstances very likely to recur, and the court determines to make recidivism less likely that the offender shows a certain amount of remorse. The court determines, though, that the defendant poses the greatest likelihood of committing future crimes. On the felony 4, the CCW, there is no presumption in favor of community control because of the PRC violation and the prior prison terms, and because it was possession of a firearm. On the 2 felony 1s, there is a presumption in favor of prison, and there is not a lick of evidence here by which the court could override that presumption in favor of prison. The court determines that prison is needed to protect the public from future crime, that a minimum sentence would demean the seriousness of this offender's conduct. The court believes that consecutive sentences are necessary to protect the public and punish this offender. They would not be disproportionate to his conduct and the danger he poses. That the crimes were committed while on post-release control, that the harm is so great or unusual that a single term would not adequately reflect the seriousness of his conduct, and his criminal history shows that consecutive terms are needed to protect the public from future crime. Accordingly, it is the sentence of this court, Anson Bryant, that you serve a period of incarceration in state prison. The court hereby terminates your post-release control, and I am imposing the balance through November 15th of 2020. I believe that comes up to 623 days, according to the DRC's calculation. Court sentences you to prison on count 1, aggravated burglary, felony 1, for 8 years, and 3 years on the firearm specification. Court sentences you on count 3, aggravated robbery.
There it is. Once the judge announces consecutive sentences are necessary, the writing is basically on the wall. Consecutive means these prison terms stack one after another, instead of running at the same time. That's the difference between walking out in several years and potentially spending decades behind bars. This is exactly why sentencing hearings matter just as much as the trial itself.
2 weapons charges, count 6 and 7, concurrent with each other and concurrent to all of the other charges, the offenses. However, the court makes the 2 F1s consecutive with one another, and therefore the order of serving your prison time would be PRC time first, followed by the gun spec on count 1, followed by the gun spec on count 3, followed by count 1, followed by count 2, for a total of 22 years with credit for 231 days. The court determines that you have or will have the ability to pay restitution. Court determines that the defendant has shown no remorse whatsoever. I was giving him remorse, a certain amount of remorse in mitigation of the sentence. The defendant has shown me that he has no remorse whatsoever, and therefore the court determines that maximum imprisonment is needed. He poses the greatest likelihood.
Did you catch that? The judge says the defendant showed no remorse whatsoever. That's a devastating observation coming from the bench. While remorse alone doesn't determine a sentence, judges often consider genuine accountability when deciding how much leniency to show. Here, the opposite happened. Combined with the defendant's criminal record, the judge